attorney with Global Rights for Women and will be the moderator today. And I'm going to hand it over to Nazifa Wazirzada, our program coordinator, to talk a little bit about the webinar logistics for this morning.
Good morning, everyone. Yes, I'm just going to go through some logistics for today. Just to let you guys know that you can type your questions into the question feature throughout the webinar, and the moderators will monitor them and pose your questions throughout the presentation when the time is right. And a recording of the presentation will be sent to all of you. And the CLE accreditation for these webinars will be applied for. So look out for those.
Thank you, Nazifa. So many of you know that this panel is part of a webinar series that Global Rights for Women has been doing since the beginning of April, when our community started to lock down during COVID-19. But just a little background on our organization. We're a nonprofit based in Minneapolis, Minnesota, and we work with leaders around the world to advance women and girls' human rights to live free from violence through legal reform and institutional and social change. And we know many of our partners, international partners, are on the call today. We're really excited to see you, as well as our colleagues from the United States. So welcome, everyone. I want to turn it over now to our panelists. We're really excited about this panel today. And I'll just have you kind of in order of that you're listed on the screen. Please introduce yourselves, tell us your role, what community you're coming from, and a little bit about your background working with violence against women cases. So John, we'll start with you.
Good morning, everybody. My name is John Choi, and I'm the elected county attorney or district attorney here in St. Paul, Minnesota. St. Paul is the capital city for the state of Minnesota. It's the second largest county in the state. I've been the chief elected prosecutor here in my community since January of 2011. Prior to that, I was serving as the St. Paul city attorney here in St. Paul. And so I've been working on issues related to violence against women, sex trafficking, domestic violence, and combating sexual assault for the big part of my career. It's a big part of the work that I've been. So it's just a real pleasure to be here with all of you from around the country and the world to talk about this topic, especially during this challenging time during this pandemic. So thanks for having me.
Thank you. And Chelsa Beaver.
Hi, I'm Chelsa Beaver. I am an assistant Stearns. Can you hear me?
Yes.
Okay. Hi, I'm Chelsa Beaver. I am an assistant Stearns County attorney. So for those that aren't generally familiar with Minnesota, Stearns County is about an hour north of Minneapolis, St. Paul area. Our demographic is about 160,000 people. Right now, in terms of COVID-related cases, our numbers are consistent with Ramsey County, who has 3.5 times more people than we do as a county, so definitely a challenge. As an assistant county attorney, I started in Stearns County back in 2013. I have handled only intimate partner violence cases since 2016, and the lead prosecutor for our Stearns County Domestic Violence Court.
Thank you. Meriel Lester?
Good morning. I am also in the Stearns County Attorney's Office. I'm an assistant chief there doing some supervision as well as a caseload. I have been in the Stearns County Attorney's Office and an attorney since 2007. I would say the vast majority of my career from the very beginning has been only prosecuting intimate partner violence cases. I was our lead prosecutor in our domestic violence court that Chelsa is now from the beginning, starting it in 2009 till about a couple years ago. And now I'm our lead prosecutor for our Central Minnesota Human Trafficking Task Force.
Great, thank you. And Judge Steve Aycock.
Morning, everyone. Sorry, I'm just a voice, but So I'm the chief judge at the Colville Tribal Court in the state of Washington. I have been back there since October of last year. I was previously the chief judge there for 9 years in the 2000s. Prior to this stint as chief judge, I was the judge in residence at the National Council of Juvenile and Family Court Judges, where I spent 9 years training mostly judges, but also other critical stakeholders on domestic violence cases in courts. Thank you.
Okay, as of the next slide. So to start our discussion today, we wanted to just kind of focus on why this issue is so important during this time. We know that during isolation, women are more vulnerable to violence and to coercive control by abusers with whom they live. And we've already seen some concerning statistics come out from around the United States and around the world. And in addition, there are predictions being made about how devastating COVID-19 is going to be for women. And our panelists will be kind of bringing this background into their discussion throughout the presentation today. We also want to ground our discussion in principles that we know are vital to a victim-centered approach to criminal justice, which is always essential, as I'm sure the panelists will talk about, but especially important right now. We wanted to highlight how important it is to have a community's commitment, a strong commitment to addressing violence against women through coordinated community response, through leadership by coordinated community response members in a community. And I know that the panelists will be addressing that as well. And throughout the discussion today, we're going to be asking the panelists to touch on how they're addressing these issues of access to safety, these principles as they adapt their work to COVID-19. So to start us off, Judge Aycock, we want to talk a little bit about the overall importance of criminal justice intervention and violence against women, and how that's especially coming up during this time of isolation. So I'm wondering if you can start off by describing what's happening in your community related specifically to custody determinations during COVID-19.
Sure. So we're seeing several different kinds of contacts with the court in terms of trying to get custody issues. One of those is where one of the parties believes that the other party is not following social distancing requirements, and so is asking for custody based on that. We also are seeing where we actually have had one where a party wants to have custody so they can get the relief money that was sent out in the first round of relief money. And then we're also seeing a couple of cases where there has been some violence in the home, and are asking, they've separated now and are asking for custody of the child. Those are what we're seeing in custody cases.
Okay, thank you. And Nazaf, could you go to the next slide? Okay, thank you. And Mr. Choi, would you like to add anything related to what you're seeing regarding trends in Ramsey County related to custody determinations or other issues?
Yeah, I think one thing that I could comment on is just, I just had a conversation with our police department, the St. Paul Police Department, about kind of what they're seeing as it relates to domestic violence. And they believe that there's a slight uptick of calls that they've been receiving in this particular area. But I think that because of the pandemic, before the pandemic, we had a system response to when incidents would occur in our community. Oftentimes people would call 911, police would arrive, they could be taken down to the jail, the perpetrator, and then there would be a process in place. We could be thinking about protective factors. A lot of that has changed in so many ways because of the pandemic. So while there might be a slight uptick in some of the calls that the police have been receiving, we haven't really seen an increase in necessarily the people that actually make it to the jail, who make it to a first court appearance. So this is and I know that we'll talk more about some of these challenges later on, but I think some of the things that are happening we're not necessarily seeing because the infrastructure of how we would know about what's going on it's been totally changed. I don't know if that makes sense, but I think there's a lot of things that are really different today than they were about 2.5 months ago.
Sure. Okay. And Ms. Beaver, can you talk a little bit about either respond to what Mr. Choi said, if you're seeing that also in Stearns County, similar issues, and about requests that you've been seeing from perpetrators related to no contact order modifications, and kind of how you're responding in your advocacy?
So I do think that our numbers have been pretty consistent in terms of what's coming in for review for charging. I did speak to some different officers within the St. Cloud Police Department, which is our largest city in Stearns County, and they said they feel like the number of calls that they're going on for domestic violence cases are pretty consistent for what they would have been doing previously. And talking to legal aid, they feel like their order for protection numbers are fairly close to what they would have been before. And order for protections are obviously the civil order that an individual can go and get. But they said what their fear is they're waiting in Minnesota right now, people can't be evicted. And so they think that numbers have been pretty standard, but once that eviction can go through, they think that's going to raise kind of the risk level for victims and cause more stress in relationships. And so they're expecting their numbers to rise when the eviction order is essentially lifted. In terms of no contact order adjustments, in Minnesota, we have what we call a domestic abuse no contact order that is very similar to an order for protection, but it's in our criminal file. So we have been seeing more individuals writing in asking for modification of those orders because of COVID. We're seeing it being used as an excuse for why contact needs to happen. In our typical process, is if an offender is making that request, we essentially say no. We believe that as a matter of practice, that request should be coming from the victim. We inform all of our victims what the process is to request modification. And so we think it's a safety risk to essentially force that request on the victim if it's coming from a perpetrator. When we're getting the request in from the victim, however, we are trying to really look at the individual case to see what that victim's circumstances are, and to evaluate whether or not maybe text communication or phone calls are appropriate to allow them to communicate about the children they have in common, because we understand that this is a stressful time for our victims, but we're very hesitant to agree to in-person contact right now. One, I mean, Minnesota was just under a stay-at-home order, but we're also trying to not have the victim feel even more isolated than individuals generally do in domestic violence situations.
Thank you. That's really helpful context, especially talking about how children being at home is sort of changing the field as far as what both perpetrators are asking for and what victims might need. Nazifka, can you move to the next slide, please? So we wanted to focus here a little bit on the importance of the criminal justice system in intervening to protect women and hold offenders accountable during COVID-19, and kind of how that's shifted, what challenges have arisen, and kind of what you take from your practice normally that you're applying now. So what are your good practices that that your court or your office has adopted that are really proving useful during this time, and what practices need to be adapted? Mr. Choi, I'd like to start off with asking you to talk a little bit about risk assessment, how risk assessment information is used in Ramsey County, and its particular importance during COVID-19.
Yeah, thanks, Laura. I think the first line of response obviously is going to be in the context of, typically it will be in the context of police responding to a situation. And one of the things that has been happening here in Minnesota and also across the country, we're recognizing that gathering all of the best information with this lens of keeping victims safe and looking at our work as homicide prevention, that if we know that we can gather and ask the right questions as a part of the response and the investigation of kind of what happened with respect to this incident, but also looking at the work that's being done there from an investigative standpoint to also ask very specific questions about risk and lethality, looking at those factors to determine what kind of risk the victim is at. So, you know, there's a number of questions that our law enforcement, they have a checklist that they will go through and ask, but there are some very obvious questions that go to the safety of a victim and the potential for lethality. So for instance, just the one question is, has the perpetrator ever threatened to kill you? And so there's a number of questions that would be asked, they're gathered, and then that information as a part of that assessment would be given to people then further down the chain. And so then the prosecutor would have that type of information. They could take appropriate action. That information is also given to the judge so that they can take that into account as they think about bail as well. So this concept of gathering that information, but looking at it from the standpoint of lethality and keeping the victim safe is so critical. So we have these set questions that we ask. And so I think now during this time, especially, you know, that making sure that police are following their protocols and practices around that and gathering that information around just very specifically, not just about like what happened and investigating the crime or the incident, but also about thinking about very specifically the safety of the victim.
Thank you. Do any other panelists have anything to add related to risk assessment before we move on?
I mean, we use them in Stearns County as well. I agree. I agree completely with Mr. Choi that they're very important. They've become even more important now. Our first responders do them on scene, the lethality assessment protocol, and then our victim assistance coordinators will do a further Jacqueline Campbell danger assessment when we talk to the victims on the phone. But I think the difference, they've always been super helpful, and the difference now is we can only have so many people in our jail. Our jail is trying to keep the ability to quarantine individuals, to isolate, to have the people who really, really need to be in jail now, they're still happy to keep, but to be able to have room for other people as well. And so lethality assessment, when you're talking to the judge during this time, who is hesitant to put bail on people, even in domestic violence cases, and to be able to talk to them about lethality factors that Mr. Choi talked about. One of them, there's many of them that statistically put a victim at a higher risk of being killed by their partner. And so I think they're more critical now than ever.
Thank you. Are other panelists seeing similar trends of judges being hesitant to keep perpetrators in custody? Or Judge Aycock, are you having some challenging requests? Would you like to address that question as well?
Yes. So one of the things I'm seeing is, you know, our jail is also trying very hard to keep the numbers of people down. So at this point, they've received a Bureau of Indian Affairs, which is part of the United States federal government, which funds most or many of the tribal jails around the country. And they have issued a guidance letter saying that the corrections facilities should talk to the judges, that only violent offenses should be kept in jail at this time. Of course, that would include domestic violence issues. But what we are seeing as a problem is when somebody violates either a condition of release for no contact, or when there's a protection order and they're violating it in a non-violent way. So you're not to be within 300 feet of this individual and they're breaking that by contacting them, but not actually using violence. And then the jail is saying, well, we're not going to take them, but they are brought to the court, and then I'm often ordering them to go to jail and holding them on bail. And so that's becoming a problem. Also, sometimes when there is a warrant out because we know that they have violated a condition, either again of a protection order or of a condition of release, and if it's not a violent offense, so for instance, a failure to appear, again, the jail is referring them over to the court. So they'll come into the court and say, I understand that there's a warrant. We then have them wait until we do our criminal docket and then deal with them at that time. So that's been an ongoing problem, trying to coordinate with the jail about understanding what actually is or is not a violent offense. And from my perspective and our court's perspective, the violation of a protection order, even if it's not the actual use of physical violence in the violation, is still an act of violence, because the potential and the risk of that is so high that those need to be taken into custody.
Thank you. So I want to move into talking a little bit more about the particular challenges for victims of accessing the court and accessing protection during this time. So I'd like to ask both Judge Aycock and Ms. Lester if you could talk a little bit about challenges that you've had in court or impacts on victims that you've seen in court proceedings. So let's start with Judge Aycock.
Okay. Part of the problem, again, is just trying to get the whole criminal justice system to understand domestic violence and to really, like I was just saying, where people don't understand that the violation of a protection order is in fact a violent offense, even if it's not accompanied with physical violence, just because of the level of risk that's involved. And without that sort of understanding of how domestic violence works and what the impact is on victims when they're being told by the police department, well, he didn't hit you, so I'm not going to do anything, even though they're in fear, but nothing's happening when somebody is violating those orders. And so that is something that really needs to be understood by everybody in the system, that how that impacts victims of domestic violence. In our case, and in a lot of tribes around the country, if you've been watching any of the US news, you'll see that many tribes, as part of their response to the COVID-19 virus or the coronavirus, has been to shut down their casinos because of just keeping people at home, not having large gatherings. For many tribes, that's a huge part of their income, which they use to fund their government. So in our case, we have 3 casinos. All 3 were closed down. They're just now opening back up. But because of that, for 2 months, there was no income coming in. So a lot of essential versus non-essential dialogue went on. And one of those was that the probation officers were considered to be non-essential and were all laid off. So at this point, we don't have a probation officer that's active during the day. She's actually works helping elders during the day as part of her response to the virus, but then at night she's trying to catch up and do some work around the probation, but she's not actually getting paid to do the probation at this point. And then one of the things that is also a challenge for me, at least, and I think for most people, is that a lot of places are now trying to do remote hearings, and so much of domestic violence assessment has to do with credibility. And when you can't see the person, so if you're doing them by phone and all you have is this disembodied voice, it's very difficult to try to figure out who's credible and who's not credible, because it very, very often comes down to, she says he did this, he says I didn't do it, or if I did it in response to something that she did. And then you have to figure out, well, who's being credible and who's not credible here in terms of this. Now, that doesn't come up so much in criminal cases as it does in actually trying to do the protection orders, but it can come up in terms of setting conditions of release, particularly where either the victim is in court giving information to the judge about what happened in terms of what bail should be set, or has passed that information on through advocates to the prosecutor, who's now advocating for protection orders or other kinds of high bail maybe. And then you have the defendant and defense counsel then saying why it is that they shouldn't, and that there's really, you know, one of the ones we had the other day was, so the woman, when initially contacted by the police, said nothing happened, but there were two victims. Her and her mom were both victims of this violence. Mom then tells the police what happened. The daughter doesn't hear what mom says, but the police go to the daughter and say, well, you know, we've talked with your mom and she's given us a different story. And without telling her what it is that her mom said, the daughter then explains what really happened. In the police report, then it says that she has told inconsistent stories. And so because of that, then the defense gloms onto the inconsistent stories. Therefore, there's not really anything here that's a problem. And this person should be allowed to be released on his own recognizance. So having people in front of you that you can see and you can assess them is really important, I think, in this time.
Thank you. Ms. Lester, can you talk about some of these current concerns and how they're rising in your county, whether it be victims' access to court, these kind of credibility issues when you're advocating for a victim, and also challenges related to probation? If either you or Ms. Beaver want to address that, that'd be great.
Sure. So just to kind of talk about what Judge Aycock was talking about, our jail is still taking violations of protective orders, whether they're the civil ones or the criminal ones. In Minnesota, it's a mandatory arrest, so there's no discretion for the officer. And then because of that, and because of the communication and partnership we have with our jail, their understanding of that, they don't try and figure out, was it quote unquote violent, the contact or anything. So any sort of violation of an order is still going to jail, still being heard in front of a judge right away. We in Minnesota, as Chelsa or Ms. Beaver stated, we're under a stay-at-home order until just Monday, this last Monday, and then now currently it's still pretty much staying at home for the most part, I guess. There's businesses are starting to slowly open up, but for our courthouse, we aren't having any in-person hearings. If the defendant's in custody, they're still appearing remotely from the jail. The judge might be in the courtroom for those hearings, but the attorneys are remotely. Most of us are working from home, or they're remote in their office. But the judge is always able to see the defendant. And so for criminal cases, at least, as far as credibility or being able to still see facial expressions and things like that, they're able to do that. One of the biggest things that we kind of pride ourselves on in our county is the rate that we can prosecute our domestic violence cases, how quickly they go through the system. And the reason that we think that's a big deal is for victims, for their closure, for their ability to move on with the case, whether they're quote unquote cooperative or not cooperative, whatever that means to people at different times. We firmly believe that letting them know what's happening with their case and having their case move through the system quickly and efficiently is a very important thing. And that's the biggest struggle that we're having right now, and then communicating with victims, is that things are kind of stalled. We're starting to have a few more hearings added on here and there, but we are in Minnesota looking at, there's a couple of pilot projects happening, I guess, to try and potentially do some social distancing jury trials in Minnesota in June. I'm very skeptical of that. If somebody can figure that out, great. The earliest the rest of our counties, probably the 84 other counties are going to be able to do jury trials right now is after the 4th of July holiday, July 6th. That I'm also very skeptical of, at least happening in often. I was told yesterday by our courthouse, and we have large courtrooms, a very large courtroom actually, and I was told we don't have the space to do a felony jury trial in our county. And so it's going to be looking at our civic centers, school gymnasiums. I mean, it's just, the cases are going to be stalled for a very long time, and that's disheartening to me for the victims. And as Ms. Beaver talked about with, requests to modify DANCOs, like it gets to be a long time of, we're trying to balance protecting victims, doing that patriarch job of saying, I know you want contact, but this is really concerning. He strangled you, he threatened you. And it's a tight balance, especially the longer this lasts. And this has had a real effect on their life and their ability to move forward. And so that's the hardest thing, one of the hardest things I think right now for us. And Ms. Beaver, I think, was going to talk about probation stuff.
So in terms of probation, like they have, like Mr. Aycock, is that I think how I say Judge Aycock's last name, and Ms. Lester indicated, there's some difference in how counties are handling the pre-trial of coming in and charging individuals whether or not they can be arrested. One of the challenges we're seeing right now is whether or not probation can issue warrants for people's arrest when they violate things like drug testing or kind of whereabouts lines, some of those more limited conditions, not the failure to remain law-abiding. And so that is a challenge for us. We're having to go back and have kind of a step-by-step process in terms of taking it back to why somebody using meth is a danger. And my position is that meth is always a danger to a victim, but we're really having to tie it back to the initial case to show why that's a problem in this particular offense, which is a challenge. Drug testing is extremely limited right now in Stearns County. So typically we would have a situation where everybody would be ordered to call in every day, and if their number comes up, they have to go in and give a random UA. That's not happening right now. The testing center is closed. So instead of that, a probation agent has to make a determination that they think somebody might be using, and that's based on the person's behavior. And then they have to schedule an appointment for them. They might only have appointments for 3 hours, 1 day a week to accommodate testing. And so that's just simply not enough when we're talking about a large caseload. And so that is a huge challenge right now, that probation is not allowed to have in-person meetings with offenders. They can't go into people's homes to search to make sure that there's not contraband. They can't go in to see if the victim might be inside an offender's residence in violation of a no contact order. They really can't do the things that they typically would do in domestic violence caseloads here in Stearns County to ensure victim safety, which is a big struggle, because when we have offenders that are put on probation, our office communicates with those victims and they tell them about the services that our community offers them. And some of these people are supposed to be in prison, and we're given departures because we have intensive supervision agents within Stearns County. And we tell victims they're going to be safe, and now probation can't do all of the things that they previously have, and that's a significant concern for us.
Thank you. So just to follow up, either Ms. Lester or Ms. Beaver, do you find yourself relying more on advocacy organizations or doing different types of safety planning, or how are you trying to kind of bridge this gap, if you've kind of come up with any strategies that might be helpful for listeners?
From our perspective, we just think communication is essential. We still have individuals within our office, we call them victim witness coordinators. They are not confidential, so they're not advocates, they're actually employees within our office. And those are the people that reach out to the victims to communicate regarding cases. And so we just try to tell them and be honest with them about really what's going on, so that they can try to take steps. So if we hear something like an offender is acting kind of strange, and while we might not have that positive drug test, we can tell the victim, hey, based on behavior, we think there might be use. We do work with Anna Marie's, which is our local domestic violence shelter. Unfortunately, their safety planning classes were suspended due to COVID. They now have just started safety planning classes again. So that is something that we're really excited about, because that was a big concern for us that they were unable to do those things. Anna Marie's locally does go on scene for any domestic violence related call. They would go out to the scene and meet with the victim right away. Unfortunately, because of COVID, they were unable to do that, but they were still calling and talking to that victim right away. So again, that's a service that they just tried to modify. It's not as great as in-person communication, but they're doing their best. And so we're really just trying to use the resources around us and use the people within our office to just keep victims informed.
Great, thank you.
If I may, following up on what Ms. Lester was talking about, so we've also suspended jury trials, and our tribe, like the state of Washington, has a 60-90 day speedy trial rule. So if you're in jail, you get a trial within 60 days. If you're out of jail, you get a trial within 90 days. I have found good cause to exclude all the time that we're closed because of the virus from that time, as has the state of Washington and the federal courts here in Washington as well. Part of my concern is when we open back up is, will people respond to a jury summons? I keep saying, if I was asked to come to a jury trial on the first week of July, I would say, no, thank you. Call me next January, maybe, and maybe I'll think about coming. So that's going to be a problem as well. And in terms of this sort of social distancing jury trials, the National Center on State Courts issued a press release, I think yesterday, saying that Texas had done the first, what they think is the first social distancing jury trial, although it wasn't really a jury trial, but there was a jury involved. But and they were saying that they think that in the future they may do more of that, and they think part of their analysis was that maybe attorneys would be more willing to represent people in rural areas where there aren't very many attorneys if they didn't have to drive hours to go to the courthouse in terms of doing a trial. And my initial response to that was, can you imagine asking the attorney to actually be in the courtroom with their client during a trial? I mean, it is beyond me how, as a litigator, I could actually do a trial where I'm not with my client in the courtroom. I don't understand how that's going to work, but they at least tried it, and it's the they did the spread out the jury into the gallery, and I guess it worked, but I don't see how it's really going to work in these kinds of cases.
Thank you. Yeah. You had mentioned using telephonic arraignments as a way to provide victims with at least the beginning of a speedy, a speedy process. Nazif, I'm going to ask you to go to the next slide, because we're starting to kind of address this issue of victim safety and offender accountability, and how do we get to that during COVID-19. So Judge Aycock, could you talk a little bit about what you've done, kind of your strategy there?
Yeah, so our infrastructure is such that we tried to do Skype or other kinds of platforms to do arraignments, and and it just it didn't work. So for safety of all of the people involved, we've made a determination that when a defendant is put into jail, they're isolated, they are tested for the virus, but it may take a few days before they get a test result back. And so we have a 72-hour arraignment rule, and sometimes the test doesn't come back within 72 hours. So we made a determination that if you do not have a negative test, you cannot come to the courthouse. You cannot come into the courtroom. So for those people, then what we are doing is doing telephonic arraignments. And again, it's a little more difficult trying to figure out what's going on. It's very difficult for the attorney who gets appointed at the beginning of the hearing, because that's when we do that. Is one of the very first things is get them an attorney appointed. And then suddenly, we're into like a bail or conditions of release, and the attorney can't even lean over and whisper to the defendant about how they should respond to the prosecutor's recommendation. And also, even if they wanted to, the jail will not let anyone come in who's not a defendant or an employee. So even the public defenders can't go to the jail to talk to their clients. They are allowed to have telephone conversation, but that doesn't work very well when the defendant is in jail, the public defender is in the courtroom, and everything that's being said is all public and being recorded. And so it's difficult, but in terms of making sure that we at least the defendants some rights, and not just, well, you're just going to have to stay in jail for the next 6 months until we decide what to do with you. And that's not appropriate either. So we're trying to do that as well. If they have tested negative, we're actually doing in-person hearings in our courthouse. So anybody that comes in has to have a mask on. If they have supporters that want to be there for them during their arraignment, they're allowed one person to be supportive of them. If anybody wants to call a witness, the witnesses are waiting outside the courthouse in their cars, and then our bailiff goes and gets them and brings them in. They get tested at the door with by temperature and question about any symptoms that they may be showing, get them in a mask, and then they're allowed to come into the courtroom. So we're trying very hard, not only, I mean, part of this is I have court staff that I have to consider as well, right? And so I have to keep them safe, and I have to keep the defendants safe, and the public safe. So it's been an interesting balancing act. And I was telling somebody the other day, whenever you do a balancing act, some interests win and some interests lose. And trying to figure out what the right balance is has been a challenge.
Sure, thanks.
But through all of that, the heaviest thing on the scale is safety for the victims and accountability for perpetrators.
Thank you, thanks. Yeah, and sticking with that, that principle, I'm wondering if Ms. Lester, if you could talk about the impact of the strong coordination within your county's criminal justice system, how that's impacted your adaptations to COVID-19 or supported your adaptations.
Sure. So in 2007, 2008, we started in our county a more formalized domestic violence partnership. And that was kind of the beginning of starting our domestic violence court. But we still, for the most part, meet every single month for 12, 13 years. And it's individuals on our partnership include individuals from our sheriff's office, from our jail, from our local police departments, from our shelter, from treatment providers, from our office, our city attorney's office. Used to include our public defenders. They no longer come to that meeting, unfortunately. And our human services, probation, multiple other people I'm sure I'm forgetting right now. But so that's, what was that?
Our judges.
Our judges, yes, 2 of our judges that I do a domestic violence court come. So that has been an important aspect for years. We saw a lot of things in that meeting, but as soon as the realization came of COVID-19 and what that would mean to our jail, and our jail knowing that we needed to get some people out of our jail, but who are we going to keep in? We had a meeting right away, you know, in, I think mid-March, and the conversations were, okay, what do we need to do with court? What do we need to do with our jail? And there was never a question in anybody's mind through all of our partners of what we would do with our domestic violence arrests. As far as new domestic violence arrests, new order for protection arrests, yes, the jail will take them. They don't bat an eye at that. You know, if there's other arrests, they're not taking, you know, gross misdemeanor warrants, misdemeanor warrants. They're not taking certain felony warrants. There's many things that our jail has not taken, but because they've been at our table and our law enforcement has been at the table for so long, it wasn't even a question in their mind that they wouldn't take our domestic violence cases. So that relationship there proved to be very helpful to us.
Thank you so much. Okay, Mr. Choi, I wanted to turn to you now. You've long been a local and national leader on the need for improved criminal justice response to violence against women in all its forms: domestic violence, sex trafficking, sexual assault. And so understanding that COVID-19 presents additional dangers and risks to women, I'm wondering if you could talk about any additional advice that you have for criminal justice professionals during this time.
Well, thank you for that question, Laura. I think because of the COVID-19 pandemic, I think that the people that are working in systems are going to be challenged, and we don't even know what I think some of the challenges are today. I mean, we've heard about the fact that we can't have the capacity to have felony jury trials. The same thing is actually happening in Ramsey County because of the physical spacing and the distancing. And so what that means is that this assembly line that we have to process all of this, it's the back end of it is not moving. And so we have this enormous backlog that's happening. And so as we have been normally addressing the issues of trying to ensure offender accountability and victim safety, all of this is going to start becoming challenging in so many different ways that I think even today we can't even entirely foresee what this will all mean, maybe 6 months down the road, because there will come a point, even if the community does prioritize domestic violence, the jail is only going to have so much capacity to keep people, and there's going to be some needs to ensure that their populations are going to be managed properly pre-trial. So I think the key thing for all of us in systems is that we really have to be adaptable to solve these challenges, but we can never forget, and I've heard many of the panelists talk about this, and I think that's the hallmark of some of the work that's happening up in Stearns County that I'm very aware of, and also here in my community in St. Paul around the blueprint for safety. But as we do our work, as we do our adapting and being flexible, we're putting very much at the forefront this notion that victim safety is the most important thing. And of course, we want to have offender accountability. And we heard Meriel talk about just the collaboration that's so critical in terms of systems talking to one another. So I think that spirit of doing that work is that is going to get us through this pandemic, as we are going to be required to do things differently, as long as we're keeping victim safety at the forefront. And we look at our work as homicide prevention, right? Because too often we wake up in the morning and we read the paper about somebody who lost her life to domestic violence. And so we can do things here in the system by ensuring that we have community support for our advocacy and for services and the things that we can do during this time. But if we keep COVID-19 at the victim safety at the forefront, I think that's one of the most important things that we can do. And then I just think one thing that I would like to add too is that we're also, in this time of COVID-19, I think all of us, not just on this call, but all of us in our society, we're spending more time with the people that we love and the people that we actually have influence over. And so oftentimes when we think about addressing sexual assault, domestic violence, trafficking, we're oftentimes thinking about, getting more services and information to victims and helping them, and we're trying to inform the public. But also, I think we need to be thinking about prevention, and we need to be thinking about important conversations that we need to be having in our society. And so we should be having conversations about how we raise boys, how we raise boys into men who don't actually do the perpetration. So just would encourage all of us to think about how to generate conversations, these important conversations around prevention, so that we can actually change our culture so that we're not just so focused on trying to respond to situations, but also thinking about a world that's much, much better.
Thank you. Now you've given us a dinner time topic too, and we're probably all tired of talking to our families about other things. So, and Mr. Choi, just briefly, you mentioned the Blueprint for Safety. For those that don't know what that is, could you just briefly describe what that is and its importance in St. Paul and Ramsey County?
Right. So the Blueprints for Safety was launched back in, I believe, in April of 2010 formally, but the whole effort there was to basically prioritize victim safety and offender accountability in everything that the system does in responding to domestic violence. Oftentimes, when systems respond, we do so in our own silos, and we think about the response in terms of my particular agency. So whether you're the 911 operator, whether you're the police department, or you're the prosecutor or the judge, oftentimes people just naturally are going to be thinking about it from like their responsibility, what they're supposed to do. And I think in many ways you can describe the justice system as kind of like an assembly line. We're there to kind of process situations and cases, get to the truth, have accountability. So the Blueprint was an effort to really coordinate all of the various silos that operate within systems to get focused very, very specifically and prioritize and look at all of our policies to focus on victim safety and offender accountability, and to kind of maximize our ability to work together to achieve that. And so it's a living document that was created through a process back in 2008, 9, and 10, and we continue every day since that time to just update it and to have connections and conversations about how to ensure that the goal of victim safety and offender accountability is at the forefront. And actually we've evolved too in so many ways in terms of kind of how we thought about some of the issues around how we should be working together back in 2010 to today. I've seen a lot of changes in terms of how we're thinking about things, and I think that's the key to a community and system response, that we're open to changes, and we're thinking about just working together and prioritizing the safety and the accountability.
Thank you. Would anyone like to share any additional thoughts about addressing victim safety and offender accountability before we move on to some questions from the participants?
I would just briefly. So one of the things that I just really want to impress upon people is communication. I think right now it's a really difficult time for everyone. And so I'm fortunate that I get to go home and I get to be safe. We have victims that don't have that luxury. And so really just keeping them informed, even if it's not what they want to hear, I think that's important. I also think it's really important for us to have the information and know what's going on with our justice partners around us. If you know what information the jail needs to take an offender, that's huge. If you know what the limits are with your probation department, you can work within those limitations. Know what resources are still out there from your local advocates. Know what your police departments are doing and talk to them. I think living in the dark is really hard. And so just knowing, even if it's not the answer you want, I can tell you from personal experience, it's a struggle for me to not be able to take certain offenders into custody. But I've tried to adapt the best that I can, and to know that maybe I can't have that offender go into custody, but maybe I can ask for a remote hearing and get that person put on house arrest with electronic home monitoring to do alcohol testing 3 times a day. So while it's not the perfect answer, it's part of the way there. And so I think just really knowing within your system, because every community is so different, really what resources you can still use is an important thing to know.
Thanks. Anyone else want to add any last thoughts about this topic before we move on to questions?
I think there's also certain technologies that would exist too across the country. I don't know like what the laws are in other jurisdictions, but we've utilized in Ramsey County as a part of conditional release the use of GPS monitoring. And so what the device is in the context of domestic violence or stalking, there is services where basically they would have like a 2-part device. So one would be like an ankle bracelet for the person accused of the crime, who would have been released on some sort of conditional release. But then the victim would also have a device that would alert him or her, or the victim, about if the offender is anywhere near the victim. So if their safety is at risk, the offender will call the victim and let them know that, and then we'll also call the offender and tell them to move away. And then of course, if that doesn't change, then they'll contact the police. We have found that in certain situations where the victim is just immensely scared for his or her safety, that this means everything for that victim. And so we have been doing this for about 8 years or so. We don't use it in every case because it is somewhat expensive, but this has meant a lot to victims of stalking and people who have this where there's an intense type of offenses going on towards a victim.
Thank you.
Mr. Choi, so who's funding? I mean, is it on the defendant or is the system paying for it?
Well, it's a combination of. So we do it. The requirement is that the offender pays. However, if the offender is subject or has a public defender, the system will pay. And so we've been paying that out of the county attorney's budget for a while. And then now the funding has now shifted to the community corrections budget. But in this time of COVID-19 and less people being held pre-trial in pretrial custody, and the fact that there's going to be a need for the sheriffs in various counties to manage their jail populations, we should be looking at, as someone had mentioned, I think Chelsa had talked about home monitoring, things of that nature, but I think these are things that can be thought of to be flexible and adaptable to the situations that we're living in today.
Right. Okay, I'm going to turn it over to Melissa. I believe there are some questions. So, Melissa, what questions do you or others have for the panelists?
Yeah, there's a question in the queue, and I'm assuming what these acronyms are, but we just encourage people that when they do questions to not use acronyms, just so that all of our listeners are clear. But the question is, are others using EM? I assume that's electronic monitoring. And then Vermont uses GPS and also sensors. We can use it when we can articulate a risk correlates. Are others enhancing the use of GPS monitoring is the question. We'll start with that one.
I can answer for us in Stearns County, I guess. We haven't, it's got me thinking when Mr. Choi was talking about it. We did a pilot project for GPS years ago, and when I was the lead prosecutor for a domestic violence court, and honestly, I just really didn't like it. I felt like if somebody was dangerous enough, that somebody was so concerned about GPS that they should be in jail. And so I didn't like that our judges were using that as an alternative to let somebody out of jail, because I saw GPS as a way to just prove a murder after the fact, that by the time somebody got through the exclusion zone, if they really were going to do something, statistically, you would have to have a radius of like 10 miles or 20 miles or something outside from where the victim lived. And in smaller communities, smaller towns, it's just not practical. But in an alternative, if somebody were going to be out of custody, no matter what, I would prefer to have them on GPS to be able to find them. So I think it might be something to maybe look at again. I guess it's never made me feel comfortable. It's not that I don't trust the technology. I know it works and it's there. It's just, to me, proving something after the fact, after something's happened.
And it has been something that has been recently talked about more by our probation department. There are different probation technology applications that they have been looking into for expense reasons, trying to figure out what program is better. It sounds like there are some GPS programs that are applications on offenders' phones. That obviously presumes that they have to keep their phone with them. It sounds like there's abilities to have them essentially call in from that phone every so often to make sure that it's still on them. But there's also technology that allows for breath tests as part of those applications within the phones. So that would be a great technology as well, which is why probation is looking into that for some of our cases. Unfortunately, the company that our probation department here in Stearns County uses doesn't have the technology like Mr. Choi described in terms of giving the victim something to carry around for distance. We had a recent case where the judge was considering releasing an individual, and so we looked into really what was going to be offered here. And the fact was that they could only put an exclusion zone on It wouldn't notify law enforcement if that person entered the exclusion zone. It only would notify a probation agent via email. And so if that exclusion zone is entered on a Saturday, when that probation agent is, not working, that would pose a problem because nobody would be immediately notified. And so that's at least the technology. So I agree. I think that GPS is better than nothing, but I think it's important to know what the GPS technology that your area actually has, because they are all different.
And at the tribe, we don't have any of that technology. There are 2 programs in our area, but they are very selective in terms of who can be on the program, and violent offenders cannot be on the program. So it's not an option for us in domestic violence cases, which is okay with me, actually, for all the reasons that Ms. Lester talked about.
Melissa, other questions?
Yeah, so thank you for that. The other question is related to expert witness testimony, and this is one I know well, of course, with Meriel and Chelsa as an expert witness myself. But the question is, do you know of anyone that's been using Zoom, still having trials and using Zoom for experts and such in cases? And so, and then also, because you're not having experts, the other question is tied to and because you did before, has it changed your negotiations at all on cases, is the question.
So for us, we obviously aren't able to have any jury trials right now. And so we use Ms. Skaya for expert witness testimony in trials. And so I think our expectation from the defense bar is they know we will call those witnesses, that we'll figure out a way to hopefully have her come in regardless of the circumstances. And so from our standpoint, it hasn't affected anything. There have been a few contested revocation hearings, which is the hearing to get somebody's probation executed. But we don't typically use an expert for that because the judge is already aware of the circumstances, and we're talking more about violations, not the underlying case. And so for us, it hasn't changed anything.
I would be interested in your answer, though, to the question about, has it changed anything related to how you negotiate in terms of plea bargains or anything? Has that changed?
So not talking about the expert, just in general, if there's a change. I do think that it has. I think that there are some cases where we've gotten to the point where we see the writing on the wall that an offender is going to be released from custody over our objection. And so we try to figure out maybe a creative solution. I just had a case that he was in custody for a very long time, and the victim was very unsure of what was going to happen, and she was frustrated in that the trial kept getting continued out. And so ultimately I talked to her and figured out a way that we could still get what she wanted, which was for a no contact order to remain in place and still hold him accountable. And so it wasn't initially what I wanted to see happen from the case 3 months ago. But in the reality of not knowing what was going to happen and that he could be released and abscond, which he's done numerous times in the past, it was the best result. And so I do think that there are some cases that, we're trying to get creative in resolution because right now too, the other thing we have to consider is it going to be a good use of resources to call in a jury? What is a jury going to think? Are they going to be mad at the state for being called for jury duty, or are they going to be upset with the defendant? And so really making that evaluation of, is this a case that under the circumstances right now that we really want to push to trial, or can we get programming, which is still happening in Stearns County. That's one thing that we haven't talked about, but our batters intervention programs are still having programming, not typically big group settings. They've done some smaller groups, some one-on-one, but so just trying to think outside the box in terms of resolution. Things have changed, yes.
And I think that's the real uncomfortable truth and the uncertainty about our future. I mean, if we can only have one jury trial room available in a community, there's just not going to be the ability to try cases. And so then that's going to require us to figure out ways to be adaptable. But again, keeping victim safety and offender accountability at the forefront, I think is going to be really critical. But I think one of the things that we could be doing is recognizing that we're going to have less access to juries, the availability of courtrooms, and then we really have to prioritize, I think, in the work in the system. Because if we can only try so many cases, but we do want to prioritize gender-based violence, violent crime, et cetera, right? Then we need to think about ways to also, creatively resolve them and deal with that. But then I think there's lots of things in the system that we're just going to have to figure out ways to deal with, like the low-level drug offenses. Just as an example, we just promulgated some guidance to our prosecutors, but we said for fifth-degree drug possession cases, we're just not going to charge them during this interim period because having them come into the system just puts a lot more stress on the limited various resources that we have. So I think we're going to be having to think about really focusing on these types of cases that involve violence, right? And then having those limited resources so that we can do the work that we need to do to have offender accountability. Because the defense knows this too, that because if there's not a jury trial, they've got certain things that they can be doing to ensure that the offender is not going to be held accountable. So we have to be thinking about those limited resources and thinking about some of the things that maybe aren't as important now in this interim period or under COVID-19.
Interesting. Ms. Lester, have you heard any similar conversations in your county about changing charging practices to prioritize cases, or has that not come up?
I mean, we've been talking about it this whole time. So we have our attorneys are all working remotely. We have, I think, maybe 140 or 150 felony complaints ready to file that we just haven't filed that have been charged. Well, people have had time and not in court as much to work on that. And so we are having the conversation with our justice partners in court about what makes sense. When do we file these? When does it, we don't want to just all of a sudden flood the system because we're already going to be in a backlog. And so I liked what Mr. Choi was saying about, prioritizing what kind of cases you put in over others. Yes, we have, half of those are probably controlled substance crimes in the fifth degree, which are our quote unquote low level drug crimes in Minnesota. And does it make sense to have a bunch of first appearance that summons all of those individuals in? I mean, our gender-based violence is generally still coming in custody. It's getting charged. We're doing those as warrants, and so those are going through the system. But there is going to be a time where, a speedy trial is a speedy trial. So if somebody demands a speedy trial on a criminal damage to property, they have every right to have that trial within the 60 days in good cause as the first-degree murder case, I guess, just to be extreme. And so when push comes to shove, we have to be making decisions, especially at the supervisory level, giving direction to people and making sure that we are prioritizing the cases that, really matter, not to say the other ones don't. It's just, it's going to be a balancing act. It really, really is at the end of the day. We are resolving cases with less jail than we did before. Some cases I think should have always been resolved that way. At some cases, it's unfortunate that you can strangle somebody and get 3 days jail. But would you rather have that conviction now and get them on probation and get the case moving along, or keep them potentially in custody where they get out, where they do the witness tampering, where the victim's life is on hold, and all of those things? So it's definitely a different world that I think, 2 months ago, we didn't know it would look like this. And in 2 months, it'll look completely different than it does right now.
Thanks.
Yeah, I agree.
Oh, go ahead.
Yeah, one of the things that we've been talking about is when we open back up, how do we prioritize juries? We have, we only do juries 2 days or 2 weeks out of the month. So we basically have 2 jury days. We have 2 courtrooms, so we can do 4 juries a month. So how do we prioritize and who's going to, I mean, seems to me those who are still in custody probably get priority number 1, but then what about all of those other people who are not in custody, and how long are they going to have to wait? And I'm telling people now at arraignment, I'm setting a jury trial for them, but I'm also telling them that it's very unlikely that they're going to be able to get a jury trial on the date that I'm telling them that they're set for. It's just unrealistic to think that this DUI person who's asking for a jury trial is going to get a trial in July when I've got 10 or 15 people who are sitting in jail who also need to get a trial. So trying to figure that out is also going to be an interesting process. And of course, as we're doing all of that, there will be new charges brought in, right? Yeah. So it's not like at some point we'll get a recess for 6 months where nobody commits a crime. So that's, you know, it'd be nice, but that's not going to happen. So yeah, it'll take a long time to get through this backlog.
Yeah. So I believe we have at least one other question, and if any participants have some final questions, be sure to type them into the question box on your control panel. But Melissa, if you can go ahead and pose the question.
Yeah, Laura, so just because of time, there's kind of 2 questions for each panelist. The first question is, what steps have the panelists taken to ensure victim privacy as they are now having to access court services virtually? And then the second question that came in privately to me for each panelist is, if you would have had a crystal ball to predict this COVID, what would you have done differently? So the first question is about dealing with privacy, issues of victim privacy using court services. And the second, if you could have planned for this, what would you have done differently?
So Ms. Lester, I'll start with you.
So, I mean, the first question regarding victim privacy, I think doesn't, I understand the question and how important it is. I don't know that it affects our criminal justice system as much because there really isn't much privacy for a victim within the criminal justice system. If there's we're doing all our hearings now, and it's a fluid situation, it changes all the time, but we're doing basically all of our hearings with Zoom, the zoom.gov account, whether they're in jail, whether they're at their home, whether they're anywhere. And so victims are, and they're public, it's a criminal hearing, and public right now means anybody can get access to that, calling in on Zoom, and the victims can, if somebody from the public called in and said, hey, I want to watch this hearing, or they can watch the hearing and be on the phone. And so there's no privacy for court hearings. There never has been in criminal cases. They're public, and anything the victim says to a government employee or victim assistance, victim witness coordinator isn't confidential either. So I don't know the answer to that as far as accessing like order for protection and things like that. As far as what I would do differently, that's, I'm like, wish I would have been called on last and got some good ideas. But I mean, I feel like right away I feel like we should have known that this was going to happen way before it did, or at least as a agency, as a government agency, we didn't plan, we didn't know. I mean, we did the best planning we could as soon as it became obvious, I guess, what was going to be happening. We had meetings right away. We talked about the jail, we talked about cases, we came up with plans and things like that. So I think we got to the right place really quickly. So I don't know, maybe 2 weeks earlier, maybe I would have had that jury trial, February 26th that got continued for no reason. So that guy wouldn't be out of custody now using meth on unconditional bail. Like, that's just like a specific example. But other than that, I don't know what we I don't know what we could have done differently other than maybe a couple weeks more of planning.
Mr. Choi?
So I would agree with the Meriel's answer about the victim privacy. So I don't know if I'm just not understanding exactly what the questioner wanted or wanted to talk about. But with respect to what would I do differently? Well, one thing is if we had bigger courtrooms, I know that we would certainly be able to accommodate the social distancing so that we could have felony jury trials in Ramsey County, or at least we're not having this problem right now where we're trying to figure out how we're going to have felony jury trials because our courtrooms are too small. But I also think that because the question presumes that like this is like the worst, like this is a very challenging time, and this is like it's very inconvenient, and there are lots of challenges, and it presumes that somehow that after all this is all done, that this was all going to be considered to be a bad thing. I also think in the spirit of kind of how we do our work, I think there are also lots of opportunities that COVID-19 can put in front of us for the system to think about how we can better serve victims in this environment. I think that no matter what, when we come out of this pandemic, we'll all remember this time, but I also think that we're going to change in some ways. And so we will always keep victim safety, offender accountability at the forefront for domestic violence, gender-based crimes. But in terms of how we do our work, I think there might be some opportunities as well. And so I think I haven't really figured out exactly what those are. But I think as we thinking about utilizing technology and thinking about kind of how we utilize this scarce resource of court, we might get better at thinking about how to maybe resolve these cases, or we might get better at thinking about how we protect victims in the context of outside of the court system, but things that community can be doing to help victims. So I think there are things that we can also benefit from by just having to exercise our flexibility and creativity in trying to solve our problems today.
So Judge Aycock, before you answer the first question, I just want to say that part of the context of that first question is that, you know, this is different from country to country, right? And I know that you're all in the United States. So I just want to point that out as part of this first question is how do you protect victim privacy? So maybe, sorry, Ms. Lester and Mr. Choi, I didn't set that context ahead of time because in the US, of course, there really isn't allowed that sort of privacy. So Judge Aycock, could you kind of just say a little bit about why the U.S. justice system doesn't allow that privacy, maybe to give context to that first question?
Sure. So one of the fundamental rights that people have in this country is the right for, if the government is going to take your liberty away, is that you have the right to have everything done in public. There's no backdoor, there's no secret courts, there's no none of that can happen once you're into the system. Everything at that point has to be done open and to the public, so that the public has the opportunity to know what the system is doing, to keep the systems accountable, yeah, so for those reasons, then all of this is done in the open. No privacy, it's all open and public. The court records that I have, including the tapes for we do it electronically, but for the recordings that we have of every hearing, anybody can come in off the street and ask for copies of any of that. And so what is still private is if there is a non-governmental advocate that's working with the victim, that information that's shared between the two of them is still private. That we can't pierce. And so there is some privacy, but generally in the criminal system, the advocate that, and at the tribe, the only advocate we have is a governmental advocate. And so because of that, then what the victim says to that individual who works in the prosecutor's office is, again, not kept private, and may in fact have to be disclosed depending on what the circumstances are and what gets said. So that would be my response to that, Melissa.
Can you just say something quick as it relates to children, just for context, to set the context as it relates to children and privacy?
Yeah, so depending upon what state you're in, if you're a juvenile defendant, those cases are either open or closed. Some states have now opened those up to the public, and in other states, they are still closed to the public. We actually don't do juvenile criminal matters at the tribe. The state does that for us. But we do child dependency kinds of cases, and those are in fact closed to the public and are sealed, and no one can find out. In fact, just yesterday in a plea bargain in a case, there's also, not only is there the criminal case, but then there's also a child welfare case. And in the criminal case, the defendant asked me to lift the no contact order that's in the child dependency case. And the prosecutor immediately said, Your Honor, that's a sealed case. We can't deal with that here. And I agreed and said, we can't. That's, talk to your lawyer about how to raise it in the other case. So it is different for juveniles, but it's still dependent upon the state. To the extent that a juvenile might be a witness to a case, most states require that the custodian, whether it's a parent or somebody that has custody, generally would have to agree to allow the child to be interviewed by the police. Obviously, once they're interviewed by the police, that's not private anymore. That's going to be disclosed. And of course, that would also not happen if it's the adult or custodian who is accused of the crime. So you're not going to ask, if the adult is accused of beating the child, you don't ask the adult whether or not the police can talk to the child, or at least that adult. You would ask, find maybe if there's somebody else. So that's how it would work with juveniles.
Thank you. So we have just 2 minutes remaining. So Judge Aycock and Ms. Beaver, could you each address the other question? What would you have done differently?
We would have sat down and planned for this long ago, and we would have thought about if this is going to happen, if something were to happen that we couldn't do the normal process, what would it look like? And the thing that I would emphasize, though, is that all the planning in the world would not necessarily make this go smoothly, because every day, as Ms. Lester said, every day is different. Things are changing every day. But yes, that's what I would have done.
Okay. Ms. Beaver?
So just briefly, quickly, in terms of privacy, because we are doing hearings remotely, victims are still able to access those, but they don't have to have their video on. They can remain muted so that they're there to listen, but don't necessarily have to let the offender see into their residence. So that's one thing in terms of privacy issues that I do think is important that our courts have allowed. The crystal ball question, in terms of my caseload, obviously I work with a population of approximately offenders of the worst, but there's only 40 of them. And so my team is a little bit different. I wish that we would have sat down sooner. It kind of just started as we're all working from home. Let's see how this goes. I wish we would have had a more concrete plan to give victims more of an answer, that we weren't going to be holding compliance hearings, that we weren't going to be able to do certain things sooner, as opposed to just kind of the rolling ball of we'll see what happens.
Thank you. Well, thank you so much for all joining us today. This has been a wonderful, very insightful conversation. I know I've learned a lot. I hope our participants have too. And I also just want to thank all of you panelists for your work on the front lines. And we're thinking of you, and I so appreciate your work to protect women's human rights, all people's human rights during this time. So thank you so much. And we hope that everyone will be able to join us for our future webinars as well. So we'll end the conference now. Thank you.